maybe you're going to some kind of a function. There are people who are doing, for example, weddings in their backyards. There are people who are saying, let's have a socially distant party in the backyard, and then sometimes alcohol makes it such, or other substances, I suppose, that you don't socially distance properly. There are issues here, you know. I don't know if you know this, and it's important, and probably and arguably more important these days than any other days. This has always been the case, at least in modern times. But right now, where there are so many things that are off limits, and people are doing DIY stuff in their homes or backyards, you can be held liable for injuries incurred at home parties, and that includes people who believe that they've contracted COVID-19 because they came to your house and were in your backyard and pressed the flesh a little bit too much. And we thought we'd talk about that because it's something you should be aware of. And joining us online is Rajiv Haté, who is a personal injury lawyer at Kotak Personal Injury Law. Good morning, Rajiv.
Good morning. Thank you so much for having me.
Well, thank you so much for making the time for us at 6:45 in the morning. Look, you heard me mention what it is. That's the short form. The long form is this is potentially serious stuff. It doesn't mean don't have a party. It means you got to be really responsible for what your guests are doing and how you're running it.
Exactly. I couldn't agree with you more. It's and that's exactly it. It's not a deterrent to say you should not have a party or not host people. It's just to, make sure you have the precautions in case, especially because we are in the middle of a global pandemic right now. And so, you don't ever want to have to face a risk of someone getting, being sued as a result of someone contracting COVID at your party or someone getting injured at a party that you're hosting at your residence.
Here's what I find really interesting. We know that there is a potential legal culpability for bars that serve alcohol beyond the scope of what a reasonable bartender who's a trained person denotes as overindulgence, let's put it that way, on the part of a guest. So you cut him off, or you grab his keys, or one of those things that you do might get you into trouble, but that's what you're supposed to do to be responsible, or you can wind up getting sued. That's a commercial establishment. Let's put that aside for a moment. The COVID-19 thing intrigues me, and probably a lot of other people out there. COVID-19 at this point is so insidious, you have no idea where you're going to get it. You have no idea where you got it from. You might think, if you're in a situation like what you're describing, and that's the only situation in a period of a month that you've been in where you were tightly involved with a number of other people, where you didn't practice any social distancing, where maybe you even hugged your old friend and shook somebody or kissed somebody on the cheek, that kind of thing. You could reasonably conclude that it came from there, but you couldn't prove it beyond a reasonable doubt, could you?
Well, and that's just it. I mean, that would really, I think, come down to sort of what the medical evidence and would suggest. But the way that I look at this is, the Occupiers Liability Act says the standard of care is one of reasonableness and not perfection, which means that you have a duty to act reasonably to prevent your guests, people visiting your house, from being injured or obtaining an illness as a result of attending your house. And so the way that I look at this is that, what's reasonable under the circumstances. I often give the example of, let's say, you have a slip and fall accident in the winter. Someone slips and falls on ice on your property. What's reasonable in the circumstances is, did you shovel and salt the driveway before they attended? And if you did, just because someone slips and falls doesn't mean you're liable. With COVID, this is obviously a very novel situation, but I think it's going to come down to, was it reasonably foreseeable that the virus could be spread? So let's say, for example, you're hosting a party and you're aware one of the guests has tested positive, but yet you allow them to come and make no steps to warn anyone else that's attending that someone with the virus is attending. I think that would likely be considered to be unreasonable, and there could be some liability on you for something like that. Now, if you have no knowledge of that whatsoever, and as far as you're aware, everybody has tested negative, I think that would be a different situation. And so, again, it really is going to come down to what's reasonable in the circumstances. And again, just because you've been out and around others, like you said, maybe hugging other people, again, it's going to depend on, were those other people tested positive for the virus, right? If you were aware of that and, again, still didn't even take any steps to warn your guests of something of that nature, then, again, there's potential liability there.
Okay, so let me ask you this because there are people out there I know thinking this right now. Well, I'm having a party tomorrow night, and we will be socially distant, and I'm not personally as aware as I could possibly be about somebody who might have tested positive but isn't manifesting any symptoms. Besides, I'm completely safe because it's BYOB.
Yeah, and so that's a great point to make, right? And I think the prudent thing to do is at least warn your guests, right? There's a risk. I mean, we're in the middle of a global pandemic, and there's also the voluntary assumption of the risk that the person may face himself, right? I mean, if you're attending a social gathering knowing that we are in the middle of where it's a viral virus spread through the air, you're sort of assuming the risk that, if you attend a gathering where there's going to be multiple people coming from different parts of the country or again, different parts of the city, there's a risk that someone may have the virus, especially because we know that symptoms don't show for a number of people. And in terms of, the bring your own alcohol, yes, that usually is a bit more of a defense to being held liable or a finding of liability against you, but it's not an absolute sort of bar to being sued, in the sense that if you are actually providing the alcohol, then yes, you have a sort of more of an obligation because you are the one who has the ability to control what is being served. Whereas if someone brings their own alcohol and is serving themselves, then yes, you may not be actually controlling what that person is drinking. But at the same time, it's happening in your house. If there's underage people involved, that's going to be another factor that's going to be considered. If there's other substances involved, illegal or otherwise, that could be another factor to consider. And so, what the court has held in terms of the Supreme Court of Canada is that, whether a duty of care exists, it really comes down to, was the injury reasonably foreseeable, and is there a sufficient proximity such that there is a duty to act, right? So meaning that there has to be some sort of connection between the parties where you would have a duty to actually act and take some steps to prevent an injury or illness from occurring.
So I'm looking at some tips that Kotak Law, your employer, has put out on this because you deal with personal injury and the potential for liability, and they are these. Have proper physical distancing protocols in place and plenty of hand sanitizer. Tell the guests to have a designated driver or take a taxi. Ensure non-alcoholic beverages and food options are available. Hire a professional smart serve bartender to control the amount people are drinking. Stop serving alcohol before the end of the party or to anybody who appears intoxicated, and designate someone to ensure the safety of your guests and safeguard against someone who shouldn't be driving. It sounds onerous, but these are really simple steps. They can be done. So I have a last question for you. The Chief Medical Officer of Health and other experts in Ontario, we're in stage 3 right across the province now. That means indoor and outdoor gathering limits are 50 and 100 people respectively. That's a reasonable number of people. If you're doing an outdoor summer party, 100 people in some backyards is a hell of a lot of people, as in you're not socially distancing. So that's where you've got, on the one hand, I want to socially distance. On the other hand, I can't, but I'm respecting the law because it's 100 people. They're at odds. Therefore, you're not really respecting the law, are you?
Exactly. That's exactly it, right? And that's where, again, when it comes down to what's reasonably foreseeable or what's reasonable in the circumstances, if you live in a mansion in a 100-acre yard where you can have 100 people socially distanced, it's going to be more reasonable to host a party like that. Whereas if you live in a townhouse or a semi-detached house and your yard is small, and if you were to host 100 people, they would effectively be shoulder to shoulder, right? And that's exactly it. And I think another tip that I would add, in addition to what you've already listed, is given that right now this COVID-19, we're still in a pandemic, maybe send out an email or a message to everyone that's attending and say, if you have tested positive, if you have any symptoms, please do not attend, right? Take that extra step to sort of protect yourself and the guests that would be attending your event as well.
All reasonable points of view, Rajiv, and very good advice as we get to the end of summer and people want to do those outdoor get-togethers before they can't for another 6 months and maybe then some. Anyway, great to have you aboard, and thanks for joining us.
It was an absolute pleasure. Thank you for having me.
All right, Rajiv Haté, personal injury